Mr. Agarwal.
Mr. Chief Justice, and may it please the Court. The President's constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the President was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this Court. And, they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy that violation. The District Court correctly rejected both arguments, and its judgment should be affirmed. On the merits, multi-member commissions with members enjoying some kind of removal protection have been part of our story since 1790. So, if petitioners are right, all three branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding era commissions and more than 24 traditional independent agencies since 1887. And this Court was wrong to repeatedly bless those laws and to unanimously uphold the exact same removal provision at issue here in Humphrey's Executor almost a century ago. Reasonable people can and do disagree about first principles, but any abstract theory that would wipe away so much history and precedent should be a non-starter. At a minimum, petitioners would need an airtight theory to justify the radical change that they now seek, and they don't have one. No tool of interpretation clearly supports the President's assertion of an unrestricted and indefeasible authority to fire the heads of traditional independent agencies like the Federal Elections Commission and the Nuclear Regulatory Commission. Plus, petitioners' theory cannot be reconciled with their own apparent position on the Federal Reserve and Article I courts. Finally, stare decisis militates against overruling a century of precedent at this late date. The political branches are more than up to the task of finding reasonable legislative solutions that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based. I welcome the Court's questions.
Was Humphrey's Executor an executive branch case?
It was an executive branch case, Justice Thomas, insofar as the FTC is an entity that is not operating under the auspices of Articles 1 and 3, but it is also a case in which Congress and the President coming together have determined that it's not part of a traditional executive department. And
did the Court in Humphrey's Executor distinguish it from its earlier precedent in Myers?
The Court, yes, absolutely distinguished the FTC from its earlier precedent in Myers.
Wasn't that distinction based on its function more as a quasi-legislative, quasi-judicial agency as opposed to an executive branch agency?
It was based in part on functions, Justice Thomas, but it was also based on the placement of the agency and the considered determination of Congress and the President together that this was the kind of agency that should be insulated from presidential at-will removal.
Now, you rely on the reliance interests and started in the reliance interests of Congress and reliance interests, I guess, of others of the agency heads on the structure of this agency for so many years. So, what is it, 70 years, you say?
The FTC is 111 years old.
But from Humphrey's Executor?
90 years.
How would you have applied that in the overruling of Swift v. Tyson, your reliance interests?
Yeah, so Swift v. Tyson deals with a completely different kind of situation with respect to the Erie Doctrine.
So there was no reliance interest?
So reliance interest with respect to choice of law determinations, I haven't thought through that systematically, Justice Thomas, to tell you the truth. I do think that there is a reliance interest here that is both immense and undeniable, and that is the fact that Congress and the President have determined that there are certain statutory authorities, not constitutional authorities, that's statutory authorities that the executive branch would never have in the absence of congressional legislation, that Congress and prior presidents thought should not be under the sole control of just one person. And that reliance interest would be completely destroyed by retroactively destroying the independence of traditional.
So This is,
agencies.
I don't know what a traditional executive administrative agency is, but could Congress limit the removal authority of the president in a newly created executive branch agency? Let's say, for example, a few years ago, EPA became an executive branch agency. It was more of an administrative agency, a sub-cabinet. Could it, in doing that, limit the removal authority of the president, of the head of the EPA, or Homeland Security?
I think it is within the realm of possibility, Justice Thomas, and I don't think that the court ex ante should adopt any kind of categorical rule precluding that.
No, I'm trying to, again, the SG was asked about the logic of his argument. What's the logic of yours? How far does it carry you? If this is an executive branch agency, and your distinction is this is a multi-member agency, why doesn't the logic take you to a single-head agency also?
So you're asking whether a single-headed agency could be converted into?
No, I haven't gotten there yet, but that would be the next step in order to make them removable, to make the heads of the agency or the principals removable.
Mm-hmm. So there are constraints. One of the constraints is that the creation of the agency and the insulation from presidential control cannot interfere with the president's conclusive and preclusive constitutional
But you
authorities.
still haven't told me, why can't tomorrow morning Congress decide that the Secretary of Congress should be removable and should limit the president's authority to remove the Secretary of Commerce?
That would be squarely foreclosed by this court's decision in Seal of Law as we understand it. And that is to say, this court in Seal of Law held that there is a particular serious threat to individual liberty that is posed by single-headed agencies that wield significant executive power.